Hello, everyone. My name is Giovanni Nogales. I'm a paralegal here at Lyles Parker. Welcome to today's webinar hosted by the Texas Association for Home Care and Hospice. Today's webinar is entitled Business Relationships with Referral Sources. Today's presenters are Ashley Morgan and Jennifer Papapanagiotou. Jennifer Papapanagiotou practice focuses on compliance, regulatory, and transactional matters for a wide array of healthcare providers, including home health and hospice agencies. She has extensive experience in analyzing proposed and existing businesses arrangements for compliance with federal and state fraud and abuse laws and drafting a wide variety of legal agreements. Ms. Papapanagiotou is knowledgeable in all aspects of state licensing for home health and hospice providers and in Medicare and Medicaid enrollment, including initial enrollment, changes of ownership, and appeals of revocation actions. Finally, she assists clients with compliance plans, forming new businesses, and addressing Medicare and Medicaid program coverage and reimbursement issues. As for Ashley Morgan, she is a partner at Lyles Parker's DC office. Ashley focuses her practice on regulatory healthcare compliance matters, fraud and abuse, and reimbursement issues. Ms. Morgan represents healthcare providers across the country in connections with a wide variety of health law issues, including coverage disputes, documentation concerns, compliance, medical board complaints, and exclusion and termination issues. She has worked with an assortment of providers, including home health companies and hospice agencies. Ms. Morgan is also a certified professional coder, a certified medical reimbursement specialist, and a certified medical compliance officer. This is just a quick reminder. If you have any questions throughout the presentation, please feel free to type them in the chat box, and we will address as many as possible at the end of the presentation. So without further ado, I present to you your speakers, Ashley Morgan and Jennifer Papapanagiotou.
Hi, everybody. This is Jennifer. Thank you for joining us during your lunch hour today. Gio, can we go to the next slide, please? Just a quick disclaimer, this is just general information that we're presenting. It's not legal advice. We always suggest that if you have questions related to the topics we're covering today, that you consult with your attorney, or our contact information will be on the last slide here. You're welcome to reach out to us. Let's go to the next slide. So just briefly, we hope to cover a few things today and focus on relationships with, we say relationships with referral sources. That's one way to characterize it. Really, it's compliance issues that we frequently deal with under a couple of relevant federal statutes that generally apply to business relationships we have with either individuals or organizations that can refer patients to your agency or that can generate business for your agency. So we're going to talk about the types of relationships that create risk, the relevant laws that apply, the interpretive guidance that's out there from all of the various regulators, and then some tips on crafting compliant arrangements. Let's go to the next slide, please. So if we dive into what are the areas where we see these issues pop up, what kind of relationships can cause concerns or compliance issues? The first are relationships with physicians. And the risky ones generally involve medical directorships when we're talking about home health and hospice. So problematic relationships can be what has been called a sham medical directorship, where a physician is paid for no services or is grossly overpaid for services. We also see sometimes issues where there are multiple medical directors with compensation that's based on the volume or value of referrals. That's not to say that having multiple medical directors is necessarily a compliance problem. It just heightens the scrutiny, and it brings home the issue that you really need to be justifying each and every relationship you have with a physician and making sure you're properly documenting it and that everyone's performing in a way that's compliant with that documentation. The other problematic area we often get questions about are relationships with marketers, whether those are employed marketers or independently contracted marketers. This can involve everything from how you pay the marketers to gifts by your marketing staff to referral sources or patients. Those are sort of the two most common areas where we get questions. Let's go to the next slide. And the third area where we see this issue pop up are relationships between agencies and facilities. Oftentimes there isn't necessarily a formal relationship, but even an informal relationship can sometimes give rise to concern. But I bulleted out some examples here. So relationships with facilities could be something along the lines of an agreement with nursing homes to send patients to your agency, excessive rent in a facility for space for the agency to utilize, providing free or below market value services to a nursing home, referring a home health or hospice patient to a nursing home in exchange for a referral back, or mining skilled nursing facility or ALF records for referrals without specific patient permission. All of these are areas where we see compliance issues pop up or that we've seen addressed in investigations. Let's go to the next slide. I wanted to just cover a couple of quick examples to give you some context for these kinds of relationships and the areas that have been under scrutiny. And I think everybody probably has heard of the Jacques Roy case if you've been around long enough. And I know we've talked about it before in previous presentations, but this is a case out of the Dallas area. Dr. Roy had 11,000 plus patients that he had referred for home health services and was affiliated with over 500 home health agencies. He often had relationships where if a home health agency would refer a potential patient to Dr. Roy for evaluation and potentially writing on an order for home health services, he would then refer them back to the home health agency, and there was an exchange of some compensation for that. There were also really unfortunate facts in this case where home health agency personnel were driving around Dallas, going to homeless shelters, pushing people on the street, knocking on doors in apartment complexes, offering food stamps or to buy groceries in exchange for Medicare beneficiary billing information. The data did not look great in the Roy case, and that's what ultimately brought them down. The case was identified and eventually investigated based on data mining, and they were looking at the volume of referrals coming from a single physician to a bunch of different agencies, some receiving significantly more referrals from Dr. Roy than others. He was the top referrer for home health services in the entire country during the time frame they were looking at. And it tripped a flag and caused a very, very large investigation. The OIG said most physicians refer fewer than 100 patients for home health a year. Some refer far fewer than that, and some are more active depending on the characteristics of their practice and the kind of patients that they serve. There were even more complicated factors in this case because when the investigation started and as they got into it, Dr. Roy, his medical practice was actually suspended by the Medicare program. And he did an end run around that and created a second practice where he continued to do the same conduct, trying to skirt around the suspension, and that got him charged with obstruction of justice. Ultimately, this case put Dr. Roy out of business and sent him to prison for quite a long time. And it also affected a number of the home health agencies that he had been referring patients to. When this happened in 2017, I've been an attorney in Texas for about 20 years at that point. There were phone calls coming in from the home health agencies that had accepted patients from him, whether they'd taken a few or a lot, and they were all being hit with suspensions or other adverse actions while this investigation was unfolding. And it was not pretty there for a while. It significantly affected a lot of the agencies in the market up there. This is just one example of a home health investigation. If we go to the next slide, I've got a hospice case. This one's out of Oklahoma City, and this was it was actually a False Claims Act investigation, so a civil investigation, where Good Shepherd was based in Oklahoma City and operated in 4 different states through 15 different offices. And someone who had worked for the business filed a whistleblower case. We call those key TMs. Whistleblower case, same thing. And it's basically a private individual filing a lawsuit on behalf of the government, alleging that someone in the Medicare program or Medicaid program has violated the law. And whistleblowers, if they're successful and if the case results in some financial either settlement or a verdict, get a cut of whatever's recovered. And the whistleblower in this case had been an executive director of one of the hospice offices for about 6 months and was witness to many of the things that ultimately were investigated in the case. And these are just some of the examples of what was going on. The hospice was hiring medical directors based on their ability to refer patients and focused on medical directors with ties to nursing homes. They had 4 or 5 medical directors who arguably only worked a couple hours a month and were receiving about $3,000 in salary. You know, paying a doctor $1,500 an hour for 2 hours of service is grossly overpaying them, well above fair market value for the service they're providing, assuming you could even document what they were doing. In addition, the hospice required the medical directors to refer a minimum of 1 patient a month to the agency to keep their contract, which is a huge red flag. Should never be requiring medical directors to refer patients. And in fact, they had terminated a medical director for failing to bring in referrals. That medical director had expressed his concern about quality of care and why he was being terminated for not referring patients, and they brushed him off. Another example, the hospice would keep at least 1 patient in a nursing home as a hospice patient so that they would continue to have access to that nursing home's records and personnel so they could market their services. That's never a good sign. Let's go to the next slide. And hospice nurses were performing the work of nursing home nurses in those facilities. And we're actually telling the nursing homes, if you'll give me 5 patients, I'll put an aide in your building all day long and you can use them any way you want. That's a huge no-no. You cannot give a nursing facility free services that are supposed to be provided by that nursing home in exchange for referrals. So kickback relationships don't always have to be money. They can also be services that are of value. Couple more examples. The hospice was paying for residents' room and board in nursing facilities, even if they didn't receive payment for that room and board due to whatever reason that might be. Again, that's an incentive to the nursing home to keep the patient there. They're getting their room and board payment from the hospice instead of, you know, through Medicaid approved funds. Hospice consultants, that's what they called them, which were really marketers, were giving out freebies to people who could influence referrals to the agency, like gift baskets and free lunches, to achieve their quota of 5 admissions a month. So they were incentivizing their marketers by rewarding them for referrals, and then the marketers were giving away free stuff in order to encourage that. That's a huge red flag in any kind of incentive program for marketers. They ultimately settled the case for $4 million and entered into a 5-year corporate integrity agreement, which, given the conduct that was present in the case, is actually pretty good for the agency. It stayed in business. So let's go to the next slide. The last case is a Texas case involving Care Committers Health Services, and this is an example of an agency that was paying group homeowners for access to and referrals of Medicare beneficiaries, and they were just paying them straight up cash, $500 for an initial certification and $250 for a recert. They were also paying marketers and recruiters to find beneficiaries, and then they were having beneficiaries sign blank home health forms. This was a criminal case that went to trial, and ultimately DeBoer was found guilty and sentenced to 9 years in prison in order to pay $3.5 million in restitution. So these are real situations. These are real examples of conduct out there in the industry, and they are low-hanging fruit for enforcement activity. Let's go to the next slide. We're going to turn and talk quickly about some of the applicable laws. I don't want to get too bogged down because these are super technical, complicated laws, but I want to give you a flavor of what's out there and what applies. Let's go to the next slide. Just as a backdrop, as healthcare spending has increased, scrutiny has also increased, and that has brought a resurgence of both administrative reviews in the form of UPIC audits, targeted probe and educate reviews, you name it, as well as civil and criminal investigation by either the Department of Justice and sometimes by the Office of Inspector General. They often work together. You should understand that UPICs, the Uniform Integrity Contractors for Medicare, are targeted. Their goal in all of the activities they do is to identify fraud and to refer cases to the federal enforcement authorities. So they've been very active, and they feed cases to DOJ and OIG all the time. And so we continue to see a high level of activity, especially in Texas, with regard to home health and hospice. The statutory requirements that you guys are expected to comply with are incredibly complex, and they change all the time. And when I say they change, the law itself doesn't necessarily, the words don't necessarily change. But case law decisions come out and interpretive guidance comes out from both Department of Justice, Office of Inspector General, all the time. And certain, fact patterns are analyzed, and it's a constantly developing area of law. So it's difficult for any individual agency to stay on top of that. And that's why people like me and Ashley spend our whole careers studying this and guiding clients through this regulatory and legal maze. Let's go to the next slide. Let's skip that one, please. Okay. So these are the major laws that are applicable to your relationships with referral sources or to your business to go out and get patients for your agency. The criminal laws that apply primarily are the Anti-Kickback statute and the criminal healthcare fraud statute, sometimes called 18 USC 1347. We talk about 1347 a lot. The civil laws that apply are the physician self-referral statute, which we commonly call the Stark Law, the False Claims Act, and the Health Insurance Portability and Accountability Act. Together, those five are sort of the heavy hitters in Medicare fraud, waste, and abuse. And they lop over into Medicaid as well. Many states also have their own laws that apply to conduct in their state. We're going to talk about the two I highlighted here in red in detail, the Anti-Kickback statute, which is the biggest federal law that we have to worry about, and the Stark Law, which is the biggest civil law that we worry about. Let's go to the next slide. So the Anti-Kickback statute is a criminal law, meaning it's an intent-based statute, and it carries with it potential incarceration and fines. And in a nutshell, it prohibits payment for referrals. It also prohibits payment to induce or reward business that is payable under a federal healthcare program. It's important that you pick up on both aspects of it, because it's not just you paying a doctor for a referral, it's also you paying anybody who could send business your direction or help you gain more business. That's why we loop in marketing when we talk about these relationships. Whether that's an internal marketer who works for your business, or it is an external, like, third-party marketing company that you're contracting with to do some kind of marketing. And there are certainly compliant ways to do both, and that's really what we're trying to hit home today. Is there are good ways and there are bad ways, and we want to stay on the side of the good ways. So any financial transaction, whether it involves money or it involves something of value, it can be what we call an in-kind transaction, among parties who refer to each other are subject to the Anti-Kickback statute. This is unlike the Stark Law, which we're going to talk about later, which for home health agencies, because Stark doesn't apply to hospice, give you a little preview there, but for home health agencies, we're largely concerned with referrals from outside sources into the agency, with the exception of marketing, where we do worry about how you pay your marketers if they're employed or independently contracted, either way. So kickback statute prohibits knowing or willful solicitation, receipt, offering, or payment of remuneration in order to induce or reward business payable under a federal healthcare program. As I said before, it can carry incarceration and fines. And as of 2018, they increased the penalties from $25,000 per violation up to $100,000 per violation. And they increased the maximum term of imprisonment from 5 to 10 years. You can also be excluded by the Office of Inspector General under its exclusion authority. Let's go to the next slide. So with all that bad stuff in mind, a little bit of context for what I said. It's an intent-based statute. You can't accidentally violate the Anti-Kickback statute. You have to have, under the Affordable Care Act, we got a little bit more statutory definition of what that intent statute, what that intent, that knowing and willful actually means. it wasn't a great clarification, to be honest with you. What they said, and this is the law passed by Congress back in 2010, a person need not have actual knowledge of this section, meaning the anti-kickback statute, or specific intent to commit a violation of this section. You just have to show that you intended to engage in the conduct that violated the statute. So it's a step back from what we call specific intent, where you have to actually know you're violating a law or a specific law. This is something that gets interpreted over and over and over again in case law, and changes, you know, what you have to show a knowing and willful violation of the anti-kickback statute is kind of an evolving thing over time. So what we've the standard we lived with for many, many years, what we call the one purpose rule. And it essentially said that even if there were lots of other valid reasons for a financial relationship with a referral source, if even one purpose was to improperly induce referrals, then the government could show a violation. They felt like that was too restrictive, I guess. I'm not sure what spurred them to want to change it to what we now have under the Affordable Care Act, which is essentially you don't have to have actual knowledge, you just have to have an intent to have engaged in conduct that violated the law. Nonetheless, when we're analyzing relationships, really think about both of these. We think about the one purpose rule, and we think about the changes under the Affordable Care Act. Let's go to the next slide. The good news is that Congress understood when they created this law that there are lots of relationships out there in the healthcare industry that are legitimate and that need to be able to exist. Home health and hospice agencies need to be able to have medical directors, and in many states you can't employ those people directly, Texas being a good example because of corporate practice of medicine. You have to independently contract with them, and they needed to create a way for those relationships to exist that didn't violate the law. And what they did was the statute instructed the Office of Inspector General to create what we call regulatory safe harbors for certain business arrangements and practices that, while on their face they might look like a violation of the law, they would be permitted as long as certain safeguards were put in place to prevent fraud and abuse. It's important to understand that safe harbors are voluntary. Just because you don't meet a safe harbor doesn't mean you violate the law. It just means that that business relationship will be subject to greater scrutiny, and you have to be able to show that the parties did not have that knowing and willful intent to engage in conduct that violated the anti-kickback statute. There are currently 25 different safe harbors. In order to benefit from these regulatory safe harbors, you have to meet every single criteria. You can't just be like 5 out of 7. You have to show you can meet every single criteria. The most commonly used safe harbors are for employees, relationships with employees, personal services and management contracts, space leases, equipment leases, and investment interests. New safe harbors get added periodically. We also get clarifications of existing safe harbors. In fact, we had a big round of those a couple of years ago where they put out some new value-based safe harbors that were intended to address value-based arrangements, payment arrangements, and they also provided clarification and tweaked some of the really heavily used ones like the personal services and management contract safe harbor. They actually liberalized it a little bit, made it easier to comply. We're going to talk now, let's go to the next slide, and we'll dig into the personal services safe harbor a little bit because it's used a lot in agency relationships, especially with medical directors. So these are the requirements for this safe harbor. It's a long list. It has to be a written signed agreement. It has to cover all the specifics of the services that let's say the physician is going to provide to the agency for the term of the agreement. It has to be for a minimum of 1 year. And the methodology, this is a change from what it used to read, the methodology for determining compensation paid to the, let's say, physician over the term of the agreement needs to be set in advance, consistent with fair market value, and is not determined in a manner that takes into account the volume or value of referrals or business otherwise generated between the parties, which may be paid for by Medicare, Medicaid, or another federal healthcare program. It can involve the counseling or promotion of a business arrangement or other activity that otherwise violates state or federal law. And the aggregate services do not exceed those which are reasonably necessary to accomplish the commercially reasonable business purpose of the services. So there's a couple of things to pick up on here. One, the first 3 are usually pretty easy to satisfy. Number 5 is actually pretty easy to satisfy. Number 4 and number 6 on this list are the ones where we get the most questions. Right now, the safe harbor says, well, you can specify the methodology as long as you do it in advance and it's fair market value and it's not based on the volume value of referrals by the physician, let's say, that you're in a contract with. What this was changed. It used to say you had to set the total compensation in advance, which with medical directors who are almost always paid on an hourly basis was never possible. And in fact, for years and years and years, hourly based arrangements with medical directors never fit within the safe harbor. They were very common, but they technically weren't compliant. We can now make those arrangements compliant. The last requirement, that the aggregate services don't exceed that which is reasonably necessary to achieve the commercially reasonable business purposes of the services, is really important to keep in mind. And this is where people get into trouble having multiple medical directors. You have to have a business reason for why you need them. You can't just keep them around because they might refer a patient. You actually need to have work for them to do that isn't duplicative of work that other medical directors are doing. And you need to be able to document what they're doing and justify the payment that you're making to them. This is why when we draft medical director agreements, we almost always require timesheets. And in addition to being very specific about the services that they're going to provide, we want that medical director turning in a timesheet every single month, describing the services that he provided that month and how much time he spent. It's a pain in everybody's rear end, but at the end of the day, it is the absolute best form of defense you will ever have if you're ever investigated over one of these relationships. And without it, you are left with anecdotal information, payroll records, and other sort of indirect documentation or evidence of what your relationship was with a physician. And frankly, those are just not nearly as persuasive as having something as simple as a timesheet that shows the days and times they worked and a brief description of their services. That's the absolute best form of defense evidence you could ever put in a file. Let's go to the next slide. The space lease safe harbor is very similar to the personal services. Written agreement covers all of the premises to be leased, term of at least a year. Rent needs to be set in advance and be fair market value and not tied to the volume or value of business otherwise generated between the parties. Doesn't involve counseling or promotion of a business arrangement that otherwise violates the law, and it does not exceed that which is reasonably necessary. So the place where people get in trouble with space leases are kind of twofold. One, they overpay for space in a facility that may have patients that are referred to the agency. So you're paying too much in rent. Or two, they lease space they never use. Just because you sign a lease in an assisted living facility and it's not protected just because you wrote a lease. You have to have a reason for that lease to exist in the first place. You have to be using that space for some business purpose. So when we work on these kinds of arrangements, we've got to be sure we're documenting why you're using it, what you're using it for, and understand that you can't just do it to somehow get money to that facility so that they'll be nice to you. Okay, let's go to the next slide. The employment safe harbor is another really important one, and this is used a lot with marketers. So it's a very broad, very generous safe harbor as long as you can meet the bona fide employee test under the IRS's statute. So remuneration, meaning what is the payment that's prohibited under the statute in exchange for referrals, does not include any amount paid by an employer to an employee who has a bona fide employment relationship with that employer. We've actually litigated criminal cases, worked with outside or with internal white-collar counsel, where this safe harbor for marketers has been key in a case. So it is very, very important that if you are employing marketers, they are treated just like every other employee. They're subject to the same kind of supervision and all of the same requirements and criteria that any other employee is subjected to. So key factors in prosecuted cases have been things like, how are you paying them? Do you pay them hourly? Are they paid pure commission? What is the incentive structure? whether that alleged employee had an office at the employer's location or was ever required to come to the employer's office, even for training. Did the employee receive the same kind of training everybody else received? Did they attend compliance training? Did they attend HIPAA training, et cetera? Did that alleged employee set their own work hours, or did they have certain hours they were expected to be on duty? Did you track that time? And then whether the employer was paying all the expenses of the alleged employee, or if there was some evidence that the employee was kind of lone rangering some things. A lot of it just is, be very mindful of how your marketers are treated, and that they are treated just like any other employee. They're subjected to all the same requirements, all the same training, et cetera. And it's always best practice that, they are like anybody else in your organization, and you supervise them like anybody else. Let's go to the next slide. So we're going to turn to civil statutes. I want to kind of get through this quickly. And I'll tell you right up front that the Stark Law only applies to a very narrow fact scenario. It prohibits a physician from making referrals for certain designated health services to an entity in which that physician or family member has a financial relationship. It's a civil statute with fines and penalties that can be assessed. It can require disgorgement of any amounts paid for tainted services or services that were referred from the physician to the entity if that relationship was improper. The government can get triple damages, and doctors and entities can be excluded from federal healthcare programs for violating this law. Let's go to the next slide. The good news is that the list of designated health services that the Stark Law applies to does not include hospice. So all the hospice people, you can take a 30-second break. But it does apply to home health. And in fact, there's a condition of payment to home health that if you have a financial relationship with a physician, that relationship has to comply with the federal Stark Law for you to be paid for any referrals that they make to your agency. Meaning, if you have a financial relationship, let's say with a medical director, and it's not written down on paper and it doesn't comply with one of the Stark Law exceptions, which we're going to talk about in a minute, every referral they make is poisoned and you can't bill for it. So that's why the Stark Law is so important and so relevant to home health. Financial relationships that are covered by the statute can include compensation relationships, ownership or investment interests. We most commonly see compensation relationships that fall under this law because it's actually very unusual to have physician investors in home health. For one, if that physician investor is ever going to make a referral to the agency, it's almost prohibited under both the Anti-Kickback statute and the Stark Law. It's very, very difficult to structure a compliant investment interest by a physician in a home health agency. So we don't see that a lot. We do see a lot in hospice, physician investment, and those investment interests still have to comply with the Anti-Kickback statute. We didn't go into that in detail, but that's something if you're looking at physician investment in a hospice and you have questions, or you didn't have an attorney help you with that and run you through that analysis, I highly recommend you find counsel to make sure you're on the right track. But let's focus here. Home health services are designated health services, so your financial relationships with individuals like medical directors are subject to this law. Stark applies to a physician financial relationship if that physician will ever refer a patient to your home health agency. It is a strict liability civil statute. You either comply or you don't. And if you don't comply, you got to pay money back, and there are fines and penalties that can be applied. Let's go to the next slide. The Stark exceptions are very, very similar to the Anti-Kickback statute safe harbors, except that they're mandatory as opposed to voluntary. You have to comply with one of these safe harbors if a physician has a financial relationship with your home health agency and they are ever going to refer a patient to you. There's a personal services arrangement safe harbor. It looks very, very similar to the Anti-Kickback safe harbor. And that agreement with that medical director needs to be structured to fit in that personal services and management contract safe harbor. Again, the criteria for that are very, very similar to the anti-kickback statute safe harbor. So you kind of get a 2-for-1. If you're going to have a physician medical director, we make sure we comply with that START exception, and we pretty much automatically then comply with the anti-kickback statute safe harbor. Let's go to the next slide. So those are the federal laws that we worry about the most, anti-kickback and START. But I wanted you to know we're in Texas, and we have our own laws in Texas that apply to fraud and abuse. The Texas Solicitation of Patients Act, which is actually found in the Occupations Code. The Texas Human Resources Code, Chapter 32, has basically a kickback statute that applies specifically to Medicaid and incorporates the federal anti-kickback statute safe harbors. We also have the Texas Medicaid Fraud Prevention Act, which is our version, a state version of the Federal False Claims Act. It's a little bit different here and there, which is very interesting. And then we've got some self-referral laws under the Occupations Code and the Health and Safety Code that are very similar to the federal statutes, and generally, virtually always, if you can meet the federal safe harbor or exception that applies, you're going to comply with Texas law. We also have the Texas Commercial Bribery Statute. And interestingly enough, there was a big case just filed, and I have this little bullet point at the end. There's a new tactic. The federal government is now using the Travel Act, which is a federal statute, to enforce state laws like the Texas Commercial Bribery Statute. What that lets them do is reach conduct that isn't covered by the anti-kickback statute. And the reason for that is that the anti-kickback statute only applies to federal payer programs, Medicare, Medicaid, and other federally sponsored health programs. So when the Department of Justice is investigating a case that involves kickbacks, but it doesn't necessarily involve Medicare or Medicaid, but it does involve other commercial payers, they have been bootstrapping cases by saying, okay, the Travel Act says that a federal prosecutor can use a state statute to reach conduct not covered by one of these other federal laws, but that is covered by a state statute. It's complicated legal theory, but they've had success with it. If you've watched the news or read anything about the Forest Park case up in Dallas, that involved kickbacks paid to induce referrals to physician-owned hospitals for out-of-network services. They ultimately prosecuted that under the Travel Act and looped in some state laws that had that, like the commercial bribery statute, to reach conduct that didn't involve federal payers. So again, there are state laws out there we need to worry about, just like we worry about federal laws. But the good news in Texas is, for the most part, if you can comply with those federal laws, you'll be okay. Let's go to the next slide. The last thing I'm going to touch on is that we do have guidelines on marketing from the Texas Medicaid program. You need to be sure that you're aware of these, and if you serve Medicaid patients and participate in those programs, that you're following this guidance. It's very similar to the guidance to Medicare Advantage plans. Prohibitions include there should be no unsolicited personal contacts, such as direct mail or email, phone, or in person. You can generally disseminate TV, radio, newspaper, internet, billboard advertising. That's fine. You can't offer inducements or giveaways of more than $10 in value. You can't offer gifts or inducements intended to influence the individual's choice of provider. The rating level on all your materials should not be greater than a 6th grade level, and it needs to be available in English and Spanish, plus others upon request. They've got a lot of materials at this website that I provided the link to, and you can submit marketing materials to HHSC for review. I've never actually participated in that process, but it is available. So something to keep in mind if you're marketing to Medicaid beneficiaries or CHIP beneficiaries. All right, I'm going to stop talking about the law. I will say on our very last slide here, there's a self-review checklist at that link that I provided on the slide before. And it's very helpful if you've got materials that you want to review under those guidelines. Let's go to the next slide. Okay, I'm going to turn it over to Ashley.
Thank you, Jennifer, for that detailed background. Let's go ahead and go to the next slide, Gio. Now I'm going to go through some interpretive guidance that's available regarding referral relationships. Let's go ahead and go to the next slide. So here on the screen are several interpretive OIG compliance materials that OIG has released on implementing compliance programs and fraud alerts as well. We've gone through these major statutes that we worry about all the time, but in addition to worrying about the actual law and the regulations, OIG is the one that is enforcing the anti-kickback statute, and so a lot of the guidance on things that you can do and not do comes from the OIG. These guidance documents help us identify problematic arrangements, tell us what the government is worried about or actively investigating, and gives us clues of how to properly apply the law. The compliance program guidance for home health agencies and hospices has actually been out for over 20 years, and it's still a really great tool for helping agencies develop and implement a compliance program. You'll see that on the screen, 1998 for home health agencies, 1999 for hospices. The fraud alerts as well from OIG identify current issues in the industry that OIG, is noticing and wants to issue an alert to all hospice providers, home health providers, et cetera, about those specific issues. So we're going to go through some of these in more detail. We'll go ahead and go on to the next slide. So first, we're going to talk about home health guidance. And the first one we're going to look at is the OIG Special Fraud Alert for home health agencies that was released in 1995. I know this was released, in 95, but it is still relevant. OIG identified a number of problematic arrangements that likely violate the anti-kickback statute. And this fraud alert specifically talks about home health agencies offering kickbacks to physicians, beneficiaries, hospitals, and rest homes in return for referrals. So these referral arrangements have been going on for a very long time, and they're still a prevalent issue that we see happening with home health agencies. We understand as counsel to home health agencies, you want to thank the people who are sending you referrals, but unfortunately in healthcare, there are very specific rules for the way things need to work. And so we have to pay attention to how we're handling these types of relationships. In this fraud alert specifically that was released, some of the conduct that was cited was providing hospitals with discharge planners, home health care coordinators, or home care liaisons in order to reduce referrals, and also providing free services such as 24-hour nursing coverage to retirement homes or adult congregate living facilities in return for home health referrals. Also subcontracting with retirement homes for the provision of home health services to induce the facility to make referrals to the agency, or pressuring physicians to order unnecessary personal care services, by saying that their patients were requesting the services and that they would refer those patients to other physicians unless they ordered them. Go on to the next slide. So the next guidance document is the compliance program guidance for home health care agencies, which was issued in 1998. One of the most helpful parts of the compliance program guidance was issued for home health agencies and then also for hospice, which we're also going to talk about, are the risk areas that the OIG identifies. For home health agencies, here are some of the risk areas that OIG identified back in 1998. And again, these are still relevant. They include home health agencies' incentives to actual or potential referral sources, such as physicians, hospitals, patients. For example, a home health agency paying a fee to a physician for each plan of care certified, providing nursing or administrative services for free or below fair market value to physicians, hospitals, or other potential referral sources, or providing salaries to a referring physician for services either not rendered or in excess of fair market value for services rendered. So again, kind of going back to that medical director relationship Jennifer was talking about, we have to be very careful if you are going to have medical director relationships about how those are structured to make sure that they're compliant, so they're not perceived as providing payment for referrals if you have a medical director that's referring patients to the agency. Another risk area that was identified were services provided to patients who reside in assisted living facilities. A big one here is space rental that does not meet the safe harbor. If you're going to lease space, it needs to meet that safe harbor. And also provision of services that are otherwise covered under the resident contract or required under state licensure. Another one was the compensation programs that offer incentives for the number of visits performed and the revenue generated. In that same home health compliance guidance, the OIG also offered guidance on policies for home health care agencies. For example, all of the agency's contracts and arrangements with actual or potential referral sources should be reviewed carefully for compliance with applicable statutes and regulations. That is a great policy to have. We recommend that you're reviewing those contracts, and I also recommend working with counsel when you're developing those contracts and also reviewing them. Having policies that the agency does not submit or cause to be submitted to the federal healthcare program claims for patients who are referred to the agency pursuant to contracts or financial relationships that were designed to induce referrals, like those that would violate the Anti-Kickback statute. And another one is that it does not offer or provide gifts, free services, or other incentives to patients, relatives of patients, physicians, nursing facilities, hospitals, etc. And another important component is you can't just have these policies in place. You also have to train your personnel on them so everybody understands the policies, and you also have to, do internal monitoring and auditing to make sure that these things are not happening and make corrections if you do identify a problem. So it's not just enough to get a policy, stick it in a binder, and never think about it again. You have to actually, execute and proceed and follow these policies that you're putting in place that the OIG is recommending. Next slide. Okay, the next one and the last one we're going to talk about for home health is an OIG alert that was issued in June of 2016. There have been several alerts that OIG has released related to home health agency. They typically cover conduct where there has been successful convictions or settlements, and OIG wants the provider community to be aware of them. In this particular one that was issued in 2016 and is still relevant, it discusses practices that OIG found to be in investigation studies of home health agencies. Specifically, there were criminal convictions and settlements that include making and accepting payment for patient referrals, falsely certifying patients as homebound, and payments for referring or soliciting Medicare and Medicaid patients sometimes involved payments to physicians disguised as payments serving as medical director. Again, those medical director relationships. We want to be very careful about how we're crafting those to make sure we're falling within safe harbors and not violating the Anti-Kickback statute. Next slide. Now we're going to talk about some hospice guidance that's been issued by the OIG as well. The first one's going to be a fraud alert that was issued in March of 1998. This one focused on the hospice overpaying nursing facilities for room and board. You can see on the slide here, OIG has observed instances of potential kickbacks between hospices and nursing homes to influence the referral of patients. Payments by a hospice to a nursing home for room and board provided to a Medicaid hospice patient should not exceed what the nursing home otherwise would have received if the patient had not been enrolled in the hospice. And then they provided a list of specific practices which are suspected kickbacks. Those include hospice offering free goods or goods below fair market value to induce a nursing home referral, a hospice paying for room and board, hospice paying amounts to the nursing home for additional services that Medicaid considers to be included in its room and board payment to the hospice, reciprocal referral relationships, hospice providing free or below fair market value care to nursing home patients for whom the nursing home is receiving Medicare payments under the skilled nursing facility benefit, and also a hospice providing staff at its expense to a nursing home to perform duties that would otherwise be performed by the nursing home. So the big takeaway from this one is really make sure you're not playing games with the room and board arrangement. Make sure you're following guidance, and if you have some sort of arrangement with nursing homes, make sure you're doing that properly. Next slide. This is the compliance program guidance for hospices, which was issued in 1999. It's similar to the guidance for home health agencies, but it does point out specific risk areas for hospice. And these include incentives to referral sources, for example, paying a fee for each terminal illness certification or providing nursing, administrative, and other services to physicians, nursing homes, hospitals, and other potential referral sources to influence referrals. Providing hospice services in a nursing home without a finalized written agreement, meaning you have to have a written agreement with a nursing home under which the hospice takes full responsibility for the management of hospice care and the facility agrees to provide room and board. Improper patient solicitation activities such as patient charting, for example, reviewing patient records in an assisted living facility without the patient's approval in order to mine resident population for services. So you're going through the EMR to identify potential new hospice patients. That's improper. And sales commission based on the length of stay in a hospice. This can cause recruitment of long stay patients whose stays may be ineligible for hospice benefits. And just like the home health, there are also policies, some guidance on hospice policies, and these include that similar to home health, all of the hospice contracts and arrangements with actual or potential referral sources are reviewed carefully for compliance with all applicable statutes and regulations. Again, we highly recommend working with counsel on preparing those contracts and reviewing them. That the hospice does not submit or cause to be submitted claims for patients who are referred in a way that would violate the anti-kickback or similar federal or state statutes or regulations, and that the hospice does not offer or provide gifts, free services, or other incentives to patients, physicians, nursing facilities, relatives of patients, et cetera, that would violate the anti-kickback statute. And again, just like I said, for home health, you need to make sure that you not only have these policies in place, but that you are also, following those policies, training your staff on them, investigating any potential violations, et cetera. Next slide. And this is a continuation on the hospice policies. These are some examples that could actually constitute potential kickback. So, some tips on what not to do. The hospice offering free or below fair market value goods to induce a nursing home to refer patients to the hospice, that would be problematic. The hospice paying room and board payments to the nursing home in an amount in excess of what the nursing home would have received directly from Medicaid had the patient not been enrolled in hospice. Again, that would be problematic. And the last one here is the hospice paying above fair market value for additional non-core services that Medicaid does not cover or consider to be included in its room and board payments to the nursing home. And the last one we're going to do here for hospice is another fraud alert. This one is an alert talking about medical director payments, and it highlights the problems that resulted in civil or criminal liability. This was issued in June of 2015, and it discusses a settlement with 12 individual physicians, and again, focused on those medical director payments. The compensation relationships that were discussed included payments that varied with the volume or value of referrals and did not reflect fair market value for the services performed. Non-performance by physicians of services called for under the agreement, which, as Jennifer was saying earlier, we highly recommend documenting what the medical director is doing because of things like this, that you're not able to prove what the medical director was doing for the payment. That has been pointed out by OIG, almost 10 years ago now. It's important to document that time so you can defend it if you need to. And payment of salaries of physician office staff. So some tips and best practices for you all. So you can try to avoid problems as best you can. It is important to educate yourself. Do something like you're doing today. Listen to educational webinars and other educational opportunities to understand the anti-kickback statute, the Stark Law, and other relevant state laws. Retain counsel. We always like to remind our clients that everything that a provider says to an investigator is considered evidence. So if you are finding yourself in a situation where you are under investigation, we recommend retaining counsel because what an attorney would say to an investigator would be considered an argument, as opposed to you saying something that could be misconstrued and be used as evidence against you later on in an investigation. A big one here is if you do not have a compliance plan in place, you need to get one in place. It is very important. And if you do have a compliance plan in place and it's sitting on a shelf in a binder that nobody has opened in the last 2 or 3 years, please get that out, look at it, make sure everybody is being trained on it at least annually. Make sure you're doing your own internal monitoring and auditing, not just on claims, but on your referral relationships as well, to make sure that those are compliant, because these are issues that are actively being pursued by the government. Next slide. For your physician relationships, you need to ensure that every relationship with a physician is documented and reviewed by a healthcare attorney. I know we've talked about this a lot today, but it is very important. We still see this being very problematic in the industry, so please make sure that to the extent you do have physician medical director relationships, that those arrangements are proper and meet the safe harbors. That your document of it needs to document, the contract needs to document a valid business rationale for the fair market of the services, fair market value of the services. The medical director should be compensated solely for clinical and administrative services. There should not be a link to referrals or admissions. Physicians should document their time to support payment for the medical director services. So have them keep that chart like Jennifer was talking about, to keep track of this are the hours that I worked, this is what I did. Keep that on file in a folder for your medical director. Hopefully you'll never need it, but that way you have it to justify those services in the event that you do. Review your medical director invoices to ensure that services provided and the hours worked are reasonable. Train your medical directors on eligibility criteria, Medicare definitions, and compliance. It's not just enough to assume that they're doing their own training or, review and education on these types of issues. You need to make sure that you are expressing and making sure that they understand the requirements as well. And monitor your relationships with outside referring physicians, their offices, and marketers as a part of your compliance program. And then another thing that's important to do if you are not doing it, you need to screen your physician referral sources and medical directors monthly for exclusions, not just on the federal OIG LEIE, but you should really be at a minimum reviewing the federal OIG LEIE, the Texas HHSC OIG exclusion database, and the CMS ordering and referring database. And there are additional state lists, and really best practice would be to review all of those state lists. I think there's 44 that are available. That is the best practice, to review each of those monthly. But we do have on the screen for you here links to the three that I mentioned, and you need to make sure at a minimum you are reviewing those, but we highly recommend that you're reviewing every state list. And it's important to make sure that those individuals are not excluded, because then they're not eligible to participate in the state and federal healthcare programs in any way, directly or indirectly. A few tips and best practices in regard to marketing staff. You need to ensure that your employees are truly employees. You need to actually look at the IRS definition. What would an investigator, be looking at if they were to come in and evaluate the relationship? So those things include behavioral control. Does the company control or have the right to control what the worker does? And how does the worker do his or her job? Financial control. Are the business aspects of the worker's job controlled by the payer? These include things like how the worker is paid, whether expenses are reimbursed, who provides the tools or supplies, and the type of relationship, meaning are there written contracts or employee type of benefits, meaning a pension plan, health insurance, vacation pay, will the relationship continue, and is the work performed a key aspect of the business? In addition, you should evaluate compensation plans for marketing employees. The compensation should not be based on admissions or length of stay. And please keep in mind that even though there is a bona fide employment safe harbor, please note that many of the cases involving employees are still problematic. Keep in mind that one purpose rule that Jennifer mentioned for the anti-kickback statute. If one purpose was meant to induce referrals, it can be problematic. Incentive payments, if any, should not be based on individual economic production. Compensation for marketing by independent contractors should meet the personal services safe harbor that Jennifer discussed, meaning that it needs to be fair market value and not based on the volume or value of referrals for independent contractors. This needs to be a fixed fee determined in advance. And the contracted services should be valid services and not a cover for referrals. So don't try, to have any funny business going on with your contract. It cannot be a cover for referrals. In addition, a few more best practices from in regard to marketing staff. Separate the marketing function from the intake and admissions function. Intake and admissions personnel should not receive bonuses based on newly admitted patients. We recommend staying away from quotas for admissions and not to fire individuals for a failure to meet goals based on quotas for admissions. Beware of it having an excessive focus on numbers and revenue. Ensure that you're checking your referral patterns and really think about, the percentage of referrals that you have coming from, any one particular provider. Unless you're really in a rural or underserved area, you probably should not have more than about 20% of your referrals coming from one physician. It can be different if, you're in a very rural area and there's not a ton of physicians there, but for providers in larger areas, you probably are going to be having more physicians that are available to refer patients, and it could look suspect if more than 20% of your referrals are coming from just one physician. We also recommend monitoring your marketing practices of independent contractors as well as your employees and their relationships with referral sources as well. And one last note on marketing staff is to avoid offering free or discounted services to other healthcare providers or facilities in connection with home health or hospice patients. And this is especially important for those hospice relationships with nursing facilities. And just a few notes on facility relationships. I know we're out of time. Is for facilities, some best practices, facility relationships, make sure you document the relationship between the home health agency or hospice in any facility. It needs to be compliantly structured, written. There needs to be a signed lease of space between the agency and any facility. And if you have a nursing home hospice agreement, that needs to be written, signed, and it needs to address the hospice responsibility for all care and the nursing home's responsibility to provide room and board. And always, if you are in doubt, ask healthcare counsel for advice before you enter into an arrangement. Don't enter into the arrangement and then 3 years later decide to ask for advice. Best practice would be to ask for advice before proceeding. All right, I think we've made it through. Do we have any questions?
So far, I don't think so. It's just about the certification. Okay. All right, let me check it. No? All right. So that concludes today's webinar. Thank you for joining us, and thank you to our speakers, Ashley Morgan and Jennifer Papapanagiotou. Everyone from today's webinar will receive copies of the presentation tomorrow via email. But if you have any other further questions about today's discussion or another healthcare law issue, please feel free to reach out to Laos Parker or to the emails that you see above. Other than that, have a good Wednesday and take care.
And thank you all so much. And if you do think of questions after the presentation, Jennifer's contact information and my contact information is available for you on the screen. All right. Thanks, Jennifer.
Thank you. Thank you.